We have filed the writ petition on 23rd. There were some defects. May I pray, my lord, it may be listed on Monday. My lord. If you.
But please, Your Lordship, with the consent of the other side,
Yes.
I'd like to mention item number 8, my lord. I have some personal difficulties today. The hearing matter, item number 8. It may be taken up after view, my lord. 8. Can it be in the first week of May, my lord?
Let the court martial think. Mr. S. Sokovil and a counsel for the respondent has made a prayer for adjournment. Who is for the petitioner? Okay.
In fact, the senior counsel A. Dasgupta is appearing. I have taken consent from
First
him.
off, Mr.
R. Ramesh.
I. Hamis.
R. Ramesh.
Ramesh, learned counsel for the petitioner who is present, has consented to the prayer as sought for and agreed to by the learned counsel for the parties, list the case on so and so.
14th May, 14/5.
5th?
14th,
Okay, 14th of May.
14/05.
Ablaji.
Unesh.
My lord, I beg to mention for listing a motion matter, my lord.
When?
If possible, my lord, tomorrow.
More.
Much appreciated.
What is your subject matter?
Subject matter regarding the contract bill, my lord.
Contract bill, not urgent.
Monday, my lord.
Daily list, order stay vacating. Items 1 and 2.
Main petition to do. Yes, Mr. Nayak.
Lordship, to as on date, Lordship, my submission will be very brief, Lordship. Lordship, basically two issues are involved. One is termination of contract of the respondent, and second one is alleged illegal allotment of work to the petitioner, Lordship. So far as the first issue is concerned, that has already been decided, Lordship. And if Lordship looks at the judgment, Lordship, that was passed earlier, only on 2 accounts, Lordship, that judgment was challenged, Lordship. Judgment is wrong. Sanjay, SK Media. I don't know, my petition to lose. Lordship, if Lordship comes to page 46 of the writ petition, Lordship.
46 of the writ petition.
Yes, Lordship. 837.
Yes.
Yes, page 46, Lordship, paragraph 38 and 39. 38, Lordship, the rival contentions of the learned counsels for the parties have been duly considered and the materials placed before the court has been duly perused. 39, the first challenge of the petitioner is against the order of termination dated so and so. The primary ground of challenge is that there is a judicial error in issuance of the same, as the jurisdiction of the jurisdiction is conferred upon the chief engineer, whereas the respondent 5 who issued termination order is an executive engineer. It is further submitted that no proper notice was served upon the petitioner. So these were the 2 basic grounds, Lordship. Allotted the contract illegally to the petitioner, Lordship, that was never discussed by this court. So far as the termination issue is concerned. Ultimately, this issue was decided, and when on being appealed, Lordship, before the division bench, this termination was never set aside by the division bench. So far as the termination is concerned, this is confirmed. This has been confirmed. So far as the illegal allotment of the contract, Lordship, Honorable Learned Single Judge, Lordship, at page paragraph, at page 50, Lordship.
Yes.
Second issue, Lordship. Learned Single Judge issued certain observations and direction, Lordship. Paragraph 50, Since public money is involved, the findings arrived by the additional chief engineer in his report, that is 6/4/2022, are required to be followed up scrupulously. In view of above discussion, the court is of the opinion that while the first challenge pertaining to termination of contract is not liable to be interfered with, the second aspect of allotting the balance work to the respondent number 6 would require certain intervention from this court, as it involves huge amount of public money and the work in question is undoubtedly of immense public importance. However, since questions of facts are involved, this court cannot play the role of primary authority. At the same time, there being glaring anomalies in the said allotment, as would reveal from the fact-finding inquiry of the additional chief engineer, PWRD dated so and so, appropriate action be taken against the erring officials, more particularly the respondent number 5, against whom specific allegations have been made, which are also substantiated in the inquiry report. Appropriate steps may also be taken against any other official involved, including the beneficiaries, in view of the prima facie finding in the inquiry report dated so and so. It is needless to state that the action to be taken has to be strictly in accordance with law by giving fair opportunity to the persons aggrieved. The writ petition is accordingly stands disposed of. So far as the second issue is concerned, it was open before the authority to look into the matter once again, Lordship. And I don't think anything has been done by the authorities wrong, Lordship, so far as in compliance of this judgment is concerned. But I also believe, Lordship, nothing can be done by the authority beyond this order, Lordship. Once it is settled by the court, so far as the termination is concerned, even if it is found that the allotment of work to the petitioner is illegal, that cannot lead to a consequence that work will again be allotted to the first terminated contractor.
It may lead to termination of this.
Yes, whatever action we need to take, Lordship, we will definitely take against him, Lordship. But that does not, breed as a consequence leading to allotting him the contract again, Lordship. That is my basic submission at this stage, Lordship.
My lords, just like to place a document, my lords, very easy. Is in the reallotment process to the petitioner, and court had directed an inquiry. Now, pursuant to the judgment, the petitioner wrote a letter to the chief engineer. That, my lord would remember, the petitioner was released almost 2 crores within 2 days. After allotment of work, within 2 days, a bill was raised and 2 crores were paid to him, which is under recovery, which has been stayed in the first.
So what is the implication of the impugn order?
Yes.
Implication of the order you seek to vacate,
My lord. My lord.
is that reallotment of the work?
Yes.
Right. Court has not commented about allotment of the work and discretion available to the PWD department to cancel it. Only interfered with by the impugn order. About perhaps I have forwarded it 2 days after 67 cases I have forwarded. But regarding reallotment of the work to the applicant in this interview, and that discussion after fact-finding inquiry to cancel the contract work in favor of the petitioner, who is the beneficiary, that issue has been left open by the single judge. But in the before the appellate court, you saw that something beneficial is coming.
Yes. It was placed.
So yes,
Yes.
you were fair to that
Yes.
submission.
Right.
I'm not commenting upon it.
Right.
So something beneficial is coming to your side. So you withdraw the writ appeal. But legality of that
Yes.
is still open.
Yes. Yes. Very true, my lord.
That is the only issue.
That is the only precise issue, my lord.
Right.
Last case, my lord had pointed.
Legality can be questioned by the petitioner. But his allotment And any decision to terminate the work or to take away the work, it's left open for the civilian. If they have not taken any decision against that, you may have, if you are a aggrieved person, you can lay a challenge to that. But court's issue before this court is that reallotment of the work. Yes, that is what. And then they started the terms of reference, framed the terms of reference as if they are sitting
On appeal again.
on appeal.
Yes.
These are the only issue which has disturbed the mind of the court tentatively.
Totally understand, my lord.
Right. That is the only issue. Let PWD cancel his contract. Or if you have a cause of action and you have a locus standi, it is open for you to challenge
Right.
that issue.
Yes,
Right.
I'm saying nothing in his favor, Lord.
Right.
I'm only
It is
questioning his
only on
locus.
the broad parameters of what the court have held
Right.
and whether this action is, and that is only tentative.
Now, this query I'll answer to my lords. I'll try and persuade my lords. I'll again reiterate, my lords. Look, what had happened, my lord, because of the inquiry, which was also part of the judgment, court had directed that you proceed with a fact-finding inquiry and you.
Right. That is what I said.
Yes, yes.
If you have the locus standi, right, and as a cause of grievance to raise it in the appropriate forum,
Yeah.
that look at your finding is very true. And the court has directed to punish the erring officials and the beneficiaries also. On that, in that sphere, if you have any cause of action, definitely. But here is a case, we are only interfering with, as an interim order, about the reallotment of the work. We are only concerned with that. We have not expressed anything about the petitioner. He has raised, how can you take the work from me impliedly and give it back to the person? Is that issue that this man has been given the balance work without any tender process? You have a locus. That is a different issue. But here, that is not the issue. You have not raised
Yes.
until and unless. Say without tender process. He's chilling. And authority is happy. Go ahead with him. Some person has to tell him that, look here, I was an eligible bidder and you have allotted the work to somebody without tender process. Yes, I may be the person whose contract was terminated, but it has to be re-tendered. Those are not the issue here. I think the problem.
Or could he?
Have I said anything more? I said anything. And that leeway is available to you.
Just one aspect, if my lords consider, my lords, that the second writ petition, in which the IA has been filed, in that writ petition, the petitioners have challenged my allotment of work, allotment given to the applicant, my lords. My lords, I would like to submit, my lords, that they do not have any locus standi to challenge it because it is their submission, my lords, their contention that they have already completed the work. My lord would find it in the.
Then they have very much, they would have locus standi to challenge.
If they have completed the work according to them, now they cannot challenge.
Mr. Mohoto, I have given you
Yes, I'm very grateful, my lord.
audience on
Yes.
that day also.
Yes, yes. Now, just one thing I would like to point out, my lord. Just one, this letter, my lord, would indicate.
This is why should I take in?
In the order passed by the department, my lord. It's an order passed by the
No, it will
department.
be
Yes,
wrong,
act on
wrong
instruction.
on the part of my friend lordship to make such
My lord,
suggestion.
my lord, kindly see
At
this.
any cost, lordship,
Where
I am
should
not.
I stay? Where should I see?
No, I am not
You
going
had
to defend
prepared-
this in
Something
lordship.
against
That has
You
nothing
had
against
prepared
the
Mr.
order.
Mohanto this bulky IA. Now you are, it is more than the repetition. Is it not? Huh? A repetition runs into how many pages? 127, right? And your IA runs into how many pages?
All documents are not annexed.
Huh?
That's the reason, my lord. We've come up with all the documents. The inquiry report. was also
Same.
not there.
126. IA is one page less than the repetition. Think of the counter affidavit. It will be running into more pages.
Well, only that, my lord, it's a work of public importance, my lord, infrastructure.
Oh, petitioner, if a public importance, you could have done it. How many years you have taken? What was the time period for completion, Mr. Mohanto?
12 months, 12 months.
12 months. When the work order was allotted?
24/1/2019.
20,
4/1/2019.
24/1/2019.
It was
What
terminated.
what was the time period for completion?
12 months, my lord.
12 months, meaning one year.
1 year, my lord.
So scheduled was 23/1/2020,
Right, my lord.
right? Termination date
9/12/2020.
9.
9 December 2020. 9/12/2020.
How much percent they said?
65%.
No.
65.
40%. It's a part of the
48%.
4G.
They are claimed that 48%. I'm not saying that you may have claimed that 100%.
Now, my lord will also note, my lords.
Now, if that is a picture emerging,
Yes.
whether
Yes.
it would be open for the applicant
Now, my lord.
to raise the issue of public interest.
Yes, my lord. Thereafter, what had transpired, my lord, would see, my lord. On 1/2/2021, there was a purported NIT which was never published. 1/2/2021.
Mr. I said,
Yes, yes.
did I not say?
That
If
part is open.
this allotment work was
Yeah.
allotted, remaining
It
part.
was paid, my lord, within 2 days.
Why don't you make an individual challenge if it is open for you? It is not that I am averse to the applicant. It is the way in which
The department has conducted itself.
all. He may be wrong. He may be on the wrong side, the petitioner. So you could have said that, yes, look here, without public notice, tender notice. Yes. Because even if my work will be applicated, but I'm still an eligible bidder since I'm not like this. And you have not seen. Although I have
Yes,
heard
yes.
say you
Perhaps
have,
because there was an element of fraud. That's why I was restored back to my original position.
Oh. He is saying, without NIT, everything alone, say. Which one is the requisition?
Where the I-
837.
Yes, 837 of
Control.
21.
Arts. The order dated 9/12/2020. Whereby the contract work under reference was terminated. Purportedly without any notice. The contract work, the difference is on the subject of work of construction. Unequal gas, Tamala, in the district of Karimganj. Pursuant to a tender process. Commander contract work was allocated to the applicant. Response number 6 had by an order. But the contract was terminated by the order dated 9/12/2020. Comma, the applicant has responded 6 heading as the verification in WPC number 2000. Everything that the authority who had issued the termination order on 9/12/2020 did not have the authority to do so. And the termination was done immediately. The court. The next thing, the next thing, after hearing. The court of clarification by judgments. 30/11/2020. The letter CEH. The court events, one of the opinion that. And reached a finding that. The challenge. Pertaining to termination of the. Contract work. Was not liable to interfere with. Custom. or in issuance of the same. The authority will issue the termination order. Was got the power. By the chief engineer. PWD Executive Department. On the issue of no performance. The according pencil bill. The order of termination dated by in amount. By another issue regarding allotment of the remaining allotment of balance to the respondent number 6 telling. Who is the opposite party number 6 that's limitation. After deliberation, command the adopted that on the same issue starting intervention would be necessary in your involvement of the government. Taking the fact that determination of factual aspects would be required. Court. Refrain from taking our primary authority. But considering the contents of considering the findings recorded after a fact-finding inquiry. Common accord in facts. And observe that appropriate action might be necessary. That dealing with people, including the beneficiary. Directing that the action be taken, the action should be taken, shall be strictly in accordance with law. With fair opportunity to the persons carrying the repetition of disposal. Well, it is it requires a mention that the repetition carrying that is that responsibility. Dealing judgment and order daily. Three 2022. 316. 311. 32. Deferred and intra-court appeal, comma, bill appeal number 397. But the writ appeal came up for consideration before the division bench. You know. 11. The submission was made to the effect that the state respondents had recalled the cancellation order and directed the concerned executive engineer to entrust the balance loan to the applicant, includes the applicant as per 6A by the communication dated 7/8/2000. And I concerned executive engineer by the communication dated 8/2000 asked the applicant as we would still state respondents come out as they of the redemption of with a further submission that the appellant while in the process of utilizing its resources the readability was sought to be withdrawn. Also granted the requirements. Granted the granted permission to the body. Yes. That's 1/6. That was 30/11, 2022. I have already said. It is not, I am not passing any judgment here.
No, I'm so, I didn't hear that.
So I corrected myself, I said that interim, inter alia.
Sorry, I'm so sorry.
Thank you. And refund of the remaining accounts. And then we can let us be. Here. The finance partner. Part of the technical. To the applicant has. Responsibilities. Ways. But this is. It didn't. And it. Where is your committee terms of reference, Mr. Mohanto?
Last page of the,
Last page of the IA.
last two pages, no?
Last page of the IA.
Page 125, last two pages.
Any date?
Inquiry report, my lord, is lying at page 79, pursuant to the 79. Was forwarded to the Special Commissioner and Special Secretary to the Government of Assam PWRD. It's for 29th of December. And the inquiry report starts
This
from
page is of what date?
my lord, the
Page 125.
agenda.
Let me read. Sir.
Yes, yes. Wait, date name again?
queries, maybe 21 7 queries. Are initiated against the RE officials. To take about the and the beneficiary will be embraced. During the inquiries. Departmental proceedings. Were ordered against two officials of the department. But the first report. Not that, but the report. inquiry Submitted by the first inquiry officer. Was found inconclusive. Else. No findings. On the charges. Were found to have been recorded. And no vision opportunity. Of getting was found to have been given to the. Getting better officials. On that ground. An inquiry officer. It has been decided to appoint an inquiry officer. To conduct. A deep inquiry. Into the charge taken against the inquiry officers. By so-called officers dated in 7,000. From the terms of reference. From the agenda of the inquiry. Comma. Which is in its. And inside of the. Comma. That. One of the. Terms of reference. Is to find out as to whether. Cancellation of contract. With the original contractor. Within the. I. Tapping and having. And. Was valid or not. The same type of reference. Consider to. Is. Again.
Agenda is a notification, madam. So
Who who is this man signing? All these? These are
all the erring officials, including the petitioner and the.
Now, what kind, who has prepared this agenda?
Inquiry officer.
There must be a committee kind of thing.
Inquiry officer, one time and chief engineer.
সেইটো কোনে নাই। এখন কোনে prepare কৰিছে?
Arjun
79.
Pedro, you say. You say, what is the name of this committee who is taking this kind of decisions?
Orders by the governor or some notification.
No date.
Date is there. Date is, my lord would find the date at page 79. If I'm correct, my lord, page 79, my lord comes to 79.
This must be dated, huh?
79 reference, government notification number so and so. If it's the same.
No number, no date.
Dated 21/7/23.
This must be part of what? Term of reference. The analysis suggests that the You want that, I can order, say that. If you want to file any counter, I can record that,
Yes,
Mr. Nayak.
counter from the
Lordship.
None of the cases we have filed. So we'll pass a common order. But- Sorry, now you are a. I missed it. You were. I observe that you are raising the public interest element.
Lordship,
I have
at this
recorded, but
stage-
I have not recorded through.
At this stage, Lordship, I am saying nothing because in the earlier order, there was a
It's a
report.
PMG.
Lordship.
Completion of work,
Completion of
something, all are disputed. But if if you want to raise the public interest, I have recorded the dates,
No,
40%.
no, not.
I have delivered it so that it would not prejudice you. But if you want to raise, I can also count.
Deeply obliged, no.
4th May, 4/5.
Okay, I'll come back then, just.
Items 4 and 5.
Okay.
Who is a senior?
Chakraborty, MSP Chakraborty.
P. Chakraborty respondent.
Respondent.
Okay. We'll hear Mr. Kotoki and Mr. Sharma first half. Then Sharma can leave in the second half.
Out of the city lordship for medical.
Sure, up to one,
Up to one.
no problem.
One, up to one I'm.
Chakraborty and two will be available. Then okay. First,
Four.
Which,
four.
not a, not a.
WBC 706 of 25.
Second copy to আছে নৰহৰিত নৰহৰিত আছে second copy to fill
Has your lordship got it?
Yes, yes.
Well, it relates to a fishery number 75, 76, 77, Romari group fishery of Bordpeta district.
Okay.
It's a 40% fishery, you know.
Deputy Commissioner is a settlement authority.
Individual also can participate.
Yes.
Huh.
Without any restriction. Was executed, this our settlement order was issued on 27/1/2017.
27.
1/17. That is at 3/17. For 7 years, at the rate of 1,41,000 per year. Yes. The period was for 27/1/2017
For
to
7 years.
7 year, 26/1/2024.
Up to
26/1/2024.
26/1/2024.
My lord, 7 years,
So it,
always date of
Okay.
proposition, but we are, according to us, this is the period.
uh,
What happened when I entered position and when I prepared for fishing, the encroacher prevented me from fishing the fishery, operating the fishery. And therefore I filed a suit, my lord, bearing title suit number 5 of 2018 in the Civil Judge Senior Division, Borpeta,
seeking recovery of position.
of the eviction of encroachers and possessions.
Eviction and recovery of position.
My lord, apart from that, I implemented the Deputy Commissioner as performer respondent. The Deputy Commissioner Borpeta filed in transposition application and accordingly allowed as plaintiff number 2. The Deputy Commissioner filed, after allowing the Deputy Commissioner application, he filed a plaint, my lord. Deputy Commissioner filed a plaint at page 19, my lord. Page 19. Lord, you kindly turn to page 22, subject of the plaint. Suit for right title interest of plaintiff number 2 inter alia of the state of Assam as paramount title holder over the Romari Group fishery land for the declaration that the defendant or illegal trespasser have no right and interest over the fishery. Look, paragraph 5 at page, your lordship kindly turn to page 6. Page 26. my lord. Your lordship got it?
Hmm.
That while the plaintiff number 1, myself, my lord, make
26.
plaintiff number 1 make preparation for fishing, the defendant restrain the plaintiff number 1 from fishing in the fishery.
Which line?
Page 26, paragraph 5. Top. Yes. On page 24. sorry. 24. Paragraph 5. That while the plaintiff number 1 make preparation for fishing, the defendant restrain the plaintiff number 1 from fishing in the fishery. On getting information, the plaintiff two directed the concerned revenue circle officer to carry on fresh survey and demarcation of Gov fishery. On survey through the concerned Lak Mandal, it has come to the light that the illegal encroachment over the suit fishery as said above. Well, admission that I could not operate the fishery here. Now the prayer at page, your lordship, 31. What was the prayer? The plaintiff prays as follows. Roman 3 to declare that the plaintiff has every right to carry on fishing as lessee of the Gulf fishery. Declare that the defendant are illegal trespasser over the suit land and have no right, title, interest over the suit land. 5 to pass a decree to evict the defendant from over the suit land and deliver khas possession in favor of plaintiff number 2. Now this suit ultimately dismissed on
Under Rule 18.
Now what happened, my lord? I already paid 4,71,725, though I could not operate it. Now they demanded the balance amount.
Yes, Mr. Sharma.
Lordship, it is a 40% fishery, though I can enlighten Lordship. We are not the administrative control over it, DC. Here, Lordship, the main fact is they
Where is the demand?
Demand at page, your lordship, 55,
Particular 57.
57. On one hand, you say that it is improved, the fishery. And the plaintiff number 1 or the
Reader could not operate the fishery.
4,71,000.
That you joined as a plaintiff number 1 strangely in the civil suit in 2018 itself. Right.
Right.
And 27/1/2017.
Yeah. Yeah. To operate the fishery. So if, and you acknowledge, it is enforced. Then how can you realize
From a citizen when he is
not in position.
and when power was available to you under Rule 18
Yeah.
to evict all the encroachers, when you possess the power,
You should have made the fishery enforcement free. But you continue with this demand notice. In fact, you should have said that you deposit 4,71,000.
whereas annual settlement value was 1,41,000. Okay, we keep since you instituted the suit in 2018, we keep 1 year settlement amount and we are refunding it.
Yes, Mr. Burua. Is it justified?
Carry no affidavit. And facts from your own action in the title suit.
Yes.
It is evident.
Evidence. It's better to keep silent, Lordship, from the government side.
Huh?
It's better to.
But in our instruction, Lordship, that the title suit things has come to our instruction. Only they have said that he has paid.
It is a decree
Yes.
of the court.
Yes.
And it is a decree that that suit is not maintainable. And the deputy commissioner had the power to evict the encroacher from the government land.
Definitely, Lordship.
And you transpose yourself as plaintiff number 2 in a civil suit where Assam Land and Revenue Regulation says in these matters, civil code has no jurisdiction. So you are not aware of your own power. Is it not laughable? So how do you defend this demand notice? Let us see the prayer. Because you instituted the suit in 2018. So far, demand is concerned, okay. They are number 1 and 2 is okay. Yes. We are not.
No, it is,
Because-
otherwise it is a illegal enrichment, my lord. My humble sir.
No, you should not have deposited it.
Lord, otherwise sometimes
No.
that is coming
Only,
in the second case.
only thing is that directing refund, these are some,
My lord.
it is not that whole fisheries. And-
My lord. The problem in the border.
No, it is not that. I have read it.
It's
That
problem.
is why I have said it.
Yes.
The whole fishery, it is not the case of the deputy commissioner, also the whole fishery is encroached.
No, sir. In border.
These are factual things.
Right, my lord.
So to civil suit, it can be said that he could not operate the fishery to realize this. So demand notices are all right.
My lord, demand notice. I complaining.
A and B,
A and B.
because otherwise, how much fishery he was able to.
Timelessly living in that party, your lordship.
This is factual determination.
One and A and B.
Yes, what do you say? How do you defend Narahari Das writ petition? You poke your head there. Yes. Amen. His lack of skill and his own power to evict the encroacher from government. And he is a settlement of the for 40% category. So how it is justified to issue that when you yourself join Narahari Das, transposing yourself as plaintiff number 2 to support his allegation that the fishery was encroached. Understanding is okay, to dictate is difficult. Okay, we'll dictate. What is the second case? Prayer A and B,
Then be, my lord.
right?
I'm,
Because Deputy Commissioner himself says in the plain that not the entire, sorry, but major part.
my
Yes, Mr. Sharma,
Sec-
and this is okay.
Second is,
Let us see second.
second one is lordship.
In first one, lordship, one in instruction, it is written that he was exercising the fishing right. Guys,
Huh?
in the first one, lordship, first case, lordship,
Okay, then take the writ petition. Take the writ petition.
but it's, although it is.
Take the writ petition.
Well, I'm not, well, it's contrary.
Take the writ petition.
Contradictory instruction. Is he?
Hill Code. Plaintiff Narahari Das was restrained from fishing by defendants. So after survey and demarcation, illegal encroachment over a suit fishery area came to be noticed by the plaintiff after collecting report from the circle officer on 24/4/2018. Legal encroachment of defendants over 160 came here. So that is why I'm not continuing with the paragraph, prayer C. What is this willfully deposited? When meaning legally is different. No. What is willful? It's a and willingly is on his own volition. Willfully. We say willful disobedience. So, that is it. Willingly is own volition. That is the only statement in the parawise comment. This is useless.
Yes.
Nothing useless. Yes. Statement before a court.
Lordship.
So this demand, when he himself admitted, that this is still always asked to not operate. And him is the power to evict the encroachment.
Aligning with him, lordship.
Aligning with him, and he did not will, when he wills a power himself
Lordship.
to make the area encroachment free. But he says that encroached. So, civil court pass a decree for the right title and possession. He owns the right title and possession. What is the need of declaration? Then recovery of possession. He is the power.
He may be wrongly advised, lordship, at that moment.
Lawyer. If you say the lawyer, it will show a bad light. Government
Actually, the
pleader.
officer is not the
And government pleader has argued it.
Lordship. That is, he is the nominal advisor. Government.
Yes, okay. Next.
WPC 10. Challenging a settlement order.
Norohari is involved here somewhat.
Yes, Norohari is the secretary of the society.
Yes, Mr.
This is myself, Lordship. Which
Kishori.
Milord, tender notice was issued,
Let
Milord.
us see the settlement order.
Settlement order at page, Milord,
34.
34.
%60?
60%. The proposed settlement of 81 Mandakur Kisari. Mandiakur. I am keeping the first one, one comparative method. MS Mandia, the society has quoted highest financial bid so and so for 7 years. But the society has not submitted a number of documents as per NIT like actual fisherman certificate, society registration certificate, resolution of the society authorizing one office bearer to submit tender, audited account and pen in the name of the society, etc. does not acceptable for non-submission of required document in terms of NIT. Now, second is mine, Milord. The society has quoted 11 lakhs 9,500 for 7 years, which is the second highest financial bid. The society has submitted all the required document except, my lord, very interesting, caste certificate in the name of the authorized office bearer, which is a must as rule 12 categorically stated that a cooperative society NGO must comprise of actual fishermen of SC community or Maimal community of East Soil Kasar district. Now the second part is the society has furnished a Bakizai certificate issued by competent authority stating there is no Bakizai dues against the society. The said certificate is shown to be valid 365 days. Whereas as per provision of RTPS Act 2012, validity of such certificate is 90 days only. My lord, I also annex that document, the respondent number 3's validity also 365 days.
Where is that? Your document and
My document is 365 days. He admitted it. I submitted their document, my lord. My document at page 26, my lord.
your document page 26.
Has your lordship got it?
Just a minute.
The certificate is valid left hand side, my lord, above the photograph.
This is Azon so and so and 365 days. Okay. And there?
They are at page 37.
Mr. Sharma, the arrow which is for Bali
Is for.
should also be for
Oh,
Supreme.
I prefer to be keep mum lordship in.
Okay. So same, more particularly another
So
thing
lordship,
glaring.
this case lordship.
This is to certify. Ultimately, this is the material part. Gobindo Sarkar, they, Gonakpara. It is in the name of Gobindo Sarkar. Come to page 26. It is in the name of the
35.
society.
35.
Page 26. What is the certificate? This is to certify.
Yes.
Pub Nohatra Borodi Fishery Cooperative Society. Secretary Norohari Das.
Not so.
And in the other one, 37. Gobindo Sarkar, Secretary, Gonakpara.
Lordship.
This is the second ground. Okay. Third ground.
Third ground will.
Where is that order again? 40.
34 Milord, order. Start from 30.
This is second. Further a complaint.
A complaint. Your lordship is taking up first item. Item number 4.
Has been filed. DDT by another society. Okay, complaint. Another society. Defaulter. Okay, defaulter.
In 5 lines.
Oh, that notice amount.
What, everything?
That is individual. Cooperative society. Seven section. Cooperative society. Society to be a body part. Which is distinct from an individual. Yes, Miss Chakraborty. Your bid is higher.
Higher.
Bakizai ground, the arrow which is for Bali, which should also be for Sugriv. Then we can declare your bid invalid. Right? That is one ground. So we'll not take exception to your Bakizai, but we'll take exception that on the same ground their Bakizai certificate should not be declared invalid. Because you cannot take a two different view like the same nature of Bakizai certificates. 365 validity is in your case, in his case also. And there is nothing what RTPS Act. RTPS has no relation. Secondly, the other one, caste certificate in the name of the authorized person. Where is the requirement? What is the requirement, Mr.? No, under Rule 12, it is not the requirement.
In 2018.
Where is the notification?
2018 notification, it is not required. Not required.
I have enacted notification also.
2018 notification. Even
And
Bakizai
the
also, I
Supreme
have,
judgment is subsequent.
even I had made a judgment in the division bench lordship. Bakizai is also not required in single bid system lordship. Bakizai certificate is also.
No, we are not going into it. Since tender notice had asked for Bakizai certificate. So. And when is the tender notice?
Tender notice at page, my lord. Tender notice page 20, 25, my lord.
This is the date?
25.
Date. Date.
Date, my lord. That's the difficulty. In Barbata, they never give any date, my lord.
In February?
February, my lord.
February 24.
No, that is last date.
22, 24, my lord.
That
The
is
last date.
Oh, no, it was the last date.
Last. So definitely in the month.
In February 2024, Lordship, in record is ended.
Let us see the impugn order. There it may be available. 2-2.
2 to 24.
Ah.
2 to 24.
2-2. And this was gazetted on the 4th of April. That will be gazetted. So it is not there. Yes, we supposed to be in the third ground. First ground, caste certificate, name of the office where it is not required. The requirement is that fishery cooperative society, registered fishery cooperative society should comprise of 100% fishermen. I think that is the requirement. Obviously, the secretary will come within that. He need not have to file a caste certificate of his own. First ground. Second ground, baki jai. Bali and Sugri. Right. Third, you want to rely on.
Certificate, therefore, their bid was not considered.
It was there, part of the record. It was part of the record. And third ground is 5,15,000. So society is a defaulter. You can be part of the board of directors in a company and you can borrow a loan from another on in your individual basis. Just because you are a defaulter in that, how can you translate? It is a body corporate as per the provision. So they are distinct from individual. So these decisions are to be set aside, but we don't finalize the bids. You have to proceed with the tender process, same tender process. Whatever. You have to set aside, and we are not relegating your bid, but they have to proceed afresh for consideration the bids, including the bid of the petitioner. Right. Only thing is that to dictate.
Problem, if you go for a fresh Lordship, in that case,
Why should I, my lord, why should I suffer?
I'm just querying Lordship, that Supreme Court judgment will prevail or not?
Which judgment?
Judgment that we have to incorporate in the, if we go for a fresh Lordship.
That is why I said it is gazette notification.
Sorry. In the judgment, although that was discussed.
That was subsequent.
Okay. Yes.
I said gazette notification. Gazette notification means state government has already taken a decision. Right. But the tender notices were not incorporating the conditions. Right. And in fact, my insistence, the State Council, some other case, produced the gazette. So many judgments were rendered only on the basis that it is a notification.
Yes.
Once it is gazetted, it almost takes the form of law.
Law. That
Unless
Now,
it is inconsistent with the rules. Notification can fill up the gaps.
Hmm.
Now that has received approval of the Supreme Court in that judgment.
yes.
Okay. We'll note the facts first.
Hmm.
Which one is earlier? You see 10 is earlier. Good more. We are taking up together. It will be difficult for me to assimilate the facts, but third ground is related to Horohori, so we have to do it. You have to be patient sitting. But I relieve you.
Third one is also there, and the third petition is also, it is very simple also. Third one.
Should I look at it? Okay, let us look at it.
In my opinion.
Just a minute, just a minute, just a minute.
Very simple.
Item 7 to deductions one, Silom. Item 7 is available.
Yes, no, please.
Yes, yes. What is to do today?
May I please also, on earlier occasion, they have filed a affidavit stating that they had issued a check of 15 lakhs. We have to take instruction whether the checks has been
Okay,
received or not.
Mr.
C. Paul.
C. Paul, Learned Counsel for the petition.
Thank you.
How much you have received now?
15 lakhs. On earlier occasion, we have received 15 lakhs.
How much is remaining?
Nothing is remaining till now.
Nothing is remaining.
11 lakhs on previous occasion, we have received 11 lakhs. And then in affidavit, they have stated they have
Take
issued a
instruction, why again all the registry should be involved? Take your instruction
Yeah.
from the client. Then we'll, if you have received, we'll close it.
2 days.
No point to involve all the registry officials to list again if you can take the instruction by a phone call.
Okay.
To list it again.
Much.
If you have received nothing, madam, have you disbursed the entire amount?
Like has been issued against this pending amount. And it is.
Or otherwise go for 138 negotiable instrument. Check bounced.
I'll take
Take your instruction. No point keeping it pending. Yes, item number 6. What is the issue here?
This is a tender notice was, it's 60% fishery milot. Number 25 Katak Tali. 4/3/2017 tender notice for the second time, milot. That is your lordship at page 14.
17.
2017, milot.
Privacy appears to be a dead horse.
My lord, I'm coming to that, milot. 4/3/2017.
Page
Page
14.
14, milot.
Yeah, what is 60%, 40%?
60%, milot.
60%.
Second tender notice. Earlier was cancelled. This is second.
Then what happened?
Then this was for party statement prepared by the deputy commissioner, forwarded to government and lying there. And in 2024, on the basis of my application, deputy commissioner wrote to the government what to do.
No point. No point. What to do? 7 years gone by. Now, what is this fisher use? 7 years. And thereafter, revenue is to be refixed by the government. No point.
No, that's correct. That's correct. Look, 7 years from the, it is not from the, it is always from the date of handing over possession, my lord.
By that time, things have changed.
No,
What is the petrol price in 2017?
my lord, but they
Fishery Yes, Mr. Tell me.
No, my lord, what
Mr.
is,
Sarma.
This can be disposed of. This NIT cannot be accepted, Lordship, because of the Supreme Court judgment, we have to issue fresh NIT. Inserting that clause. Final basic is, we have to issue fresh.
no, my lord, they have cancelled the process, my lord. Till now, no decision.
It is being issued by only Deputy Commissioner.
No, it's a 60% fishery.
Deputy Commissioner. has
No,
issued
he invites the tender.
He invited tender, that is the requirement under the rules. And forwarded to the government, my lord. Hari. Page 17 পঢ়া না বাবা, তাতে ওলাই গৈছে।
Section 40.
I already
Rule 48.
7 years per year.
These value will be fixed for a period of 7 years at a time with 10% annual increase.
10%.
Now, when no indecision, because of indecision, now it will be redone. Fresh.
I leave it to your lordship.
But what do you say?
My lord, the process was not cancelled, my lord. That's the difficult.
We have to take it, we'll direct the
Authority-
Fishery Department to take a call.
Call, my lord.
But at the same time, we'll observe as regard 48.
My lord,
There's no point.
no, my lord,
45,000 annual fishery rate.
in Borpeta, my lord.
We'll increase the as per the rate of petrol. No, there is a formula 48.
48.
Rule
Lies, yes.
there 10%
They can
increase.
enhance the permit according to that, and I am in the height bidder. And that too,
If
second.
you deposited money,
No, my lord, settlement was not, I earnest money lying there.
yes, that is what.
Ah.
That has to be taken care of.
Yes, yes, yes.
So they have to take a final decision.
Finally.
But at the same time, he will observe, he will make submission that in view of 48, everything has increased.
My lord, 48, time limit was not prescribed, my lord.
Okay. There is no private respondent in item number 6.
Item number 6, no.
What? Para. On the start. The two writ petitions. Item number 6 to Belagate with you. So my WBC number. Change to 2024. And the user number 706. Stroke 2024. Which are located in the district of Bombay. The fishery road in WPC number 10/2025. is number 81. Mandiakul Fishery. Whereas and the fishery law in the other institution of focusing on law 706 2025 is $75 76 and 77. Murray location. For your reference, the fisheries are but yes. The relatively the subject matter involved in the other repetition, comma WPC number 706 2025. The definitions are taken up together for finding that the request of the land comes to the party. But Assam Fishery Rules 1953. Part of the rule book. The Assam Fishery Rules. The state governments in the fishery department is a settlement authority. For 60%. On the other hand, comma, Romeric group fishery is the 40% category fishery. And as per rule 8 of the fishery rules, it is the jurisdictional deputy commissioner
or the additional deputy commissioner in place of several subdivision and the subdivision officers in case of other subdivision, as the case may be, is the settling author for 40% category positions. Therefore, for nobody, Monday to Friday, the state governments, the fishery department, the second. And for nobody to fishery, the idea is jurisdiction, the actually the crisis. Leading to the institutions of the two writ petitions are equal. By a tender notice dated 2/2/2024. Comma. The district commissioner for Borpeta as the tender inviting authority invited bids from eligible bidders for settlements of 1 year fishery project period of 7 years. In a tender notice, comma, the annual lease value of the fish of Mondiakur fishery was fixed at rupees 30,000 for the first year by the tender inviting authority. Full stop. As per the tender notice, comma, the last date for submission of bids was twenty 2020. In response to the tender notice, comma, 7 bidders submitted their bids. 7 bidders, including the petitioner society, that are responsible, 3 society, submitted their bids. It is important to mention that as per the provider to Rule 12 of the fishery rules, a 60% category fishery can be settled with special category of cooperative societies, non-government organizations, and self-help groups consisting of 100% fishermen in the neighborhood of the fishery concerned.
Fishermen belonging to scheduled caste community.
That is the explanation. That is the explanation. I am reading the provider.
Yes, yes.
We'll come to the notification. Then at that time. So stop.
Therefore, the tender process for Bondiakur fishery was limited to such category of bidders. On receipt of the bids, the district commissioner the bid evaluation committee constituted by the district commissioner. Sorry, not that. Open the bids on 5/3/2024. And after scrutiny of the bids and the documents submitted in support of the bid, the bid evaluation committee prepared a comparative statement indicating therein about receipt or non-receipt of the essential documents, as indicated in the tender notice, along with the bid value offered by the 7 participant bidders. As for the purpose of the list involved in the requisition, the details recorded, the particulars recorded in the comparative statement, means recording with respect of all the 7 participant bidders. And can be made limited to the biased to the three bidders, three participating bidders who had offered the bid values, comma, the yeah, are second, the following. Mainly, জমা কৰা, জমা কৰা, that's one of four. No. Page 8 in the report. All seven were not necessary, so that is why I am not reproducing it. Okay, that's not option. Where are you? As the district commissioner of it, is the tendering waiting authority. And share department in the state law is the tendering settling authority for a 62% of people say the district commissioner of it forwarding the tender papers and the cooperative statements so prepared to the fishery department. On 2/7/2000. Very good. Right. An office letter. Being for taking a final decision. The matter of settlement of Bandia acquisition. We'll come back. After examination and evaluation of the tenders. So,
Like it. And what we computes in like right for a period of 7 years on the position. Tender setting authority. From the bid of the ISB bidder. Among Messrs. Mondia. Deficient. Due to non-submission of a number of documents as part of tender notice. In respect of the the tender for Mission Society was against non-responsible by accepting the tender of the Mission Society and the responsible the highest bidder. Right, that's such a decision. Come on, the tender setting authority. And there. And I. You know, magnify. That's 83%. Big change, you know. Really. Yeah. Well, yes, feel now
fishery named Romari fishery. District of came to be settled in favor of District of comma a 40%. Came to be settled in favor of the petition. For a period of 7 years. At and offered and offered the review of rupees 1,41,000 per annum. Portion to a tender process initiated by the district commission of Africa. As the tender inviting authority come tender settlement. By an order dated 27/1/2007. Under the provisions of the fishery rules, comma, the 40% category percent. Can be settled with individual members of actual fishermen belonging to the scheduled caste, comma, Maimal community, scheduled caste, scheduled tribes, comma, Maimal community, and
Other backward classes.
apart from the registered cooperative fishery society formed by members of actual fishermen belonging to a scheduled caste, stroke minor community, stroke scheduled tribes, and other different classes. Better. As per the fishery lease executed on 27/1/2017, comma, the period of settlement of 7 years would be counted from the date of handing over the possession of the fishery on payment of the annual yearly revenue of rupees 1,41,000. Another requisite formalities. It is the case of the petitioner that after execution of the fishery rules on 27/2017, the petitioner proceeded to operate the fishery system. But due to obstacles created by encroachments, by the by persons from the nearby locality, the petitioner could not operate the fishery the satisfactory manner in another area of the fishery having an area of about 160 meters. The encroachers did not allow the petitioner to operate and fish in Romari Group fishery. Full stop. The petitioner represented before the authorities, including the tender settlement authority, to evict the encroachers who were encroaching the areas of the fishery so as to enable the petitioner to operate and fish in the fishery. When such representations of the petitioner fail into deep ears, the petitioner was constrained to institute a title suit. Title suit number 05/2018 in the Court of Learned Civil Judge in by the Senior Division Warpeta against the encroachers who were made defendants with the District Commissioner Warpeta as the correspondent. The petitioner as the plaintiff sought relief in the form of declaration of the right party interest over the areas of Lumbai Group fishery and to declare the defendants as illegal trespassers and for eviction or the dependence over the fishery, over the areas of the fishery, which was with the suit line, comma, for delivery of passports. During the pendency of title suits, comma, the district commissioner of Orpeta, who was with a performer respondent, comma, transposed, file a petition to implement for this implement as plaintiff number 2 by transposition. After the said petition for transposition was allowed, the district commission of Orpeta was made plaintiff number 1, 2. After his implement by transposition as plaintiff number 2, a district commission filed an amended plea, wherein he included 60 number of persons as defendants, as against 6 number of defendants included earlier by the petitioner as the plaintiff number 1. By the amended plaintiff, comma, believe in the form of a declaration that the defendants were illegal trespassers, having no right, title, and interest over the suit land, was sought apart from a belief in the form of recovery of past possession by eviction of the defendants from the suit land. In addition to permanent injunction. Para. In the additional claims submitted by the district commissioner of the town, it was pleaded that the lands The parcel of land measuring 357 billion below the surface, covered by government national, situated Cowboy mining block, block 3, with the Paka, whatever the revenue cycle is the product. The targets, schedule A. So out of schedule A. Comma. Then while the initial water body to be part of the fishery lease. Executed on 27/1/2017 for settlements. For a period of 7 years. At the rate of rupees 5. By the fisheries dated 27/1/2017, the plaintiff number 1 Martinez petition was allowed to enjoy the right taking in interest over the fishery. When the plaintiff number 1 was making preparation for fishing, for the defendants restrained from fishing in the fishery. So on getting such information come out, the district commissioner, jurisdictional circle officer to carry out a face survey of the fishery. And it has come out in the survey. And it had come to light in the survey that there was illegal enforcement over the fishery. The extent of encroachment of the areas of Glomari was found to the extent of 106 meters. By the defendants. The review to the amended bill, comma, the pending number 2, submitted the list, giving the details of the area, enclosed areas of Roman Court design as scheduled with the amended thing, comma, the district commissioner has taken having the area slots the following reliefs. Having the area slots the reliefs. One. Declare that the plaintiff law one has every right to carry LPC of the government. Declare the defendants are illegal trespassers over a suit and have no right to park title over a suit. We see to pass to evict the defendants from over a suit and deliver past pollution in favor of the plaintiff. Para. The Court of Private Civil Bench, seniority. Right now. Very good question. Framed a preliminary issue on 13/5/2019 to the effect that, quote, whether a suit is maintainable in its present form and manner, question mark, unquote. Full stop. The trial court heard all the sides on the preliminary issue so framed. Full stop. After hearing perusal of the materials in the case record, comma, the preliminary issue was decided by an order dated 6/2/2024. Full stop. In the order dated 6/2/2024. The trial court had taken note of the fact that the illegal enforcement of the defendants in areas of the global say was to the extent of 106 meters. As described in schedule B, comma, out of total 357 meters.
The trial court. Had found that under regulation 154 of the Assam Land Regulation of 1986, it was specifically provided that no civil court shall exercise its jurisdiction in any matter regarding assignment of any person from land over which no person has accrued the right of proprietor from a landholder or settlement holder. The Crime Court had observed that the plaintiffs were fully aware that the suit in respect of which they sought relief, suit land, was government land. Regulation 12 of the Assam Land Regulation has provided power to the state government to make rules in case any land over which no person under the regulation to provide for the disposal by way of grant or otherwise of such land, comma, the assignment of any persons who have entered into unauthorized occupation of such lands and the disposal of crops raised. Full stop. In the settlement rules came under regulation 12 of the Assam Land Regulation. Of 1986, Rule 18 had provided the power to the district commissioner, the jurisdiction deputy district commissioner, to eject any person from land over which the person had not acquired the rights of a proprietor from a landholder or settlement. By following the procedure prescribed therein, taking cognizance of the power authorities jurisdiction provided in Rule 18 of the settlement rules.
the trial court came to a finding that the power authorizing jurisdiction for ejectment of an unauthorized person on government land was vested on the district commissioner itself. The trial court reached an opinion that since the district commissioner himself is the power authority and jurisdiction to initiate the process of ejectment of illegal encroachers, encroaching the suitlands, mentioned as Schedule A land and Schedule B land. And Regulation 154 of the Assam Land and Revenue, it is 86, had barred the jurisdiction of the civil court. The preliminary issue came to be decided against the plaintiffs by holding that the suit was not meeting. Well, the further case of the petitioner is that after dismissal of title suit number 05/2000 by the order dated 6/2/2020, the deputy commissioner, district commissioner, Morpena, served 2 demand notices, dated 16/10/2025 and dated 27/1/2020 by the said 2 demand notices, similarly worded. The petitioner was informed that he, the petitioner, in spite of enjoying possession of Romani Group fishery from during the period from 27/1/2017 to 26/1/2024, failed to deposit the installment amounts in terms of the lease deed dated 27/1/2017 70. And as a result, the balance outstanding the amount, the real amount amounted to rupees 5,15,275 by the demand notices. The petitioner was asked to deposit the said amount that treasury immediately. Also, agreed by the said to demand notices. Commander of petition has instituted that is parallel. I have heard the stress property land council for the petitioners in both the reviews. I have heard Mr. S. Property. Mr. P. Sharma, the standing counsel, Fishery Department, for the response one. In both the Mr. S.R. Gurma, Learning Assam for response number 2. In WBC number 8/2025 and the response number 2 and 3. In WBC number 7/6/2025. In connection, it's WBC number 10/2025. Mr. Komobi, done in council for the petition, has pointed out that the period of the petitioner society was declared non-responsive on 3 counts. But none of the 3 counts would be sustainable in law. It was not a requirement of the tender notice dated 2/2024 that the caste certificates in the name of the authorized office bearer of the registered cooperative fishery society as a bidder was a requirement. Rule 12 of the fishery rules has not laid down over in rule 12 of the fishery rules has laid down that the caste certificate in the name of the office bearer of the either registered cooperative fishery society would be necessary. Postal. As regards Pakistan certificate. Mr. Kotal has confirmed that a similar Pakistan certificate was also submitted by the Respond number 3 society. The Pakistan certificate submitted by the Respond number 3 society with validity of 365 days would be accepted. There can be no reason for non-acceptance of the practical certificate submitted by the Petitioner Society having validity of 365 days. Both the particular certificates were issued by the same authority, that is the District Commissioner of Beta, who incidentally is the tender inviting authority. On the point of default, he has contended that the Petitioner Society, it was Rohri Das who was served with demand notices. They did dated 21/2025 and 27/1/2020, whereby a demand an amount of rupees 5,15,275 was demanded, allegedly in an illegal manner, and a Petitioner Society cannot be, and such alleged default on the part of Sri Norohari Das cannot be made relatable to the Petitioner Society, even though Sri Norohari Das is the secretary of the petitioner society. Which such contentions are submitted that none of the grounds on which the meat of the petition society was declared non-responsive is sustainably known and consequently command the impugned order of settlement dated 16/12/2020 made in favor of the respondent society is liable to be set aside and anything else? On behalf of the petitioner in WBC number 706/2025, Mr. Kotogi has submitted that the district commissioner Kolkata who is the tender inviting authority as well as the tender settling authority for Romary Group deciding had himself admitted in title suit number 05/2018 that a large chunk of area of Romary Group deciding were under encroachment of illegal trespassers. Such admission was made on the basis of a report of the circle officer, a report dated 24/4/2018 of the circle officer, whatever revenue cycle, within whose jurisdictional areas Romary Group fishery is located. The petitioner has claimed the fisheries currently Where is that? What page is it? In the lease deed. Dated 27/1/2017. It was clearly mentioned that it is within an area of 160 meters of Lomari Group fishery. The petitioner was allowed to operate and fish. When and uh, out of the said fisheries, an area of 106 meters was enforced by illegal transport trespassers. So my effect admitted by the district commissioner for the himself. This fact of enforcement is pushed on the petitioner. After the lease date dated 27/1/2017, deposited an amount of rupees 4,71,725 in such backdrop. The demand for rupees 5,15,275 by the Supreme Demand is clearly arbitrary and unjust. Whereas in response, Mr. Shobal and Standing Council when a Standing Council, Fisheries Department paying for a restaurant one. Which has not submitted, which has not brought its stand in any counter agreement. Has submitted. Has submitted that as support the order dated 16/12/2000 we have submitted that the announcement of rejection recorded against the petitioners will petitions that will be are not arbitrary. Yes, further submitted that since what we are going to say has already been settled in favor of the responsible chief society. Are you running the mission? And responsible chief society has been operating the fishery for more than 1 year without any defaults. There is no place for interference. With the Indian model, taking 16 to 2000. Mr. Borua, for the respondent number in the OBC number 10/2000 as referred to the counter affidavit filed by the same respondent. To submit that. Sri Norohari Das was settled with Romari Group Society on 27/1/2017 for a period of 7 years. From the date of ending our commission of the fishery on payment of an yearly revenue of rupees 1,41,000. And from Norohari Das and Norohari Das had defaulted to deposit an amount of rupees 5,50,275. Which amount had accumulated to the area as area. Comma. The Norohari Das, or say Norohari Das, is clearly in default. And as a consequence, the petition society, bring the OLC Norohari Das acts as a secretary. Comma is also in default. Paying for the respond number.
Two and three. In.
WBC number 706.
06, 2025. Comma, Mr. Borua.
On the basis of instructions received from the respond number 3 in the form of an office letter. Paying number PRS.
That's, take on, huh?
That's 2/97/460. Dated 24/2025. I have submitted that. The petitioner have deposited an amount of rupees
71,725 as security and installment amounts on 6 different dates.
for exercising his fishing right. He has clearly submitted that no instruction has been received as regards the demands made for the amount of rupees 5,15,000. $275 by the two impugn demand notices. It is his contention that since the petition only an area of 106 meters was an enforcement from the petitioner. The
Remaining area.
remaining areas out of
160 bighas of the fishery are still available.
such the demand for the amount of private is not unjust. In connection with WBC number 2, the Borua has submitted the package passed by the respondent number 1. There is no room. There is no room. Passing down. Parameters of the program. Depending for the respondent society. In WBC. Yes. What should I record? Has supported. Has supported the decision. Supported the order of settlement. Dated. Sixteen, 12, 2000. In your affidavit, any date of handing over? Wait. Para 95. Okay, and accept. After the order of settlement dated 16/12/2024. The respondent number 3 society was handed over possession of Pandiakur fishery on 1/1/2021. And since then, the society is operating the fishery. In the process, the Responsible Tree Society has invested a huge amount of money. And therefore, any interference with the order of settlement dated 16/12/2024 would cause immense prejudice to the respondent number 3 society. Where I am really consider the submissions. From the undisputed facts narrated in already alluded by you. It has emerged that in response to the tender notice dated 2/2/2020. Seven bidders who are registered fishery cooperative societies submitted their bids. In the tender notice it was mentioned that the bid document was to be collected bid document on the tenders were invited as per the latest rules and regulations of the government. Notification billing number dated 18/1/2018, the Fishery Department Government of Assam
had laid down a detailed procedure for submission of documents with the tender submitted for tender process pertaining to settlement of 60% category fisheries in order to bring uniformity in all tender processes initiated through tender notices published by the jurisdictional district commissioners to subdivision officers in the FC in order to maintain transparency. The same notification dated 18/1/2018 was published in Assam Gazette in its issue number 14 dated 4/4/2018. Full stop. In the over in the Gazette notification in the Gazette notification, it is mentioned that Bakijai clearance certificate is to be furnished by the Bakijai authority under the concerned deputy commissioner, where the society stroke NGO is registered, and the Bakijai clearance certificate should invariably be in the name of the society stroke NGO stroke SHG and not in the name of the office bearers of the society stroke NGO stroke SHG. Full stop. In the Gazette notification, nothing has been prescribed regarding validity period of the Bakijai clearance certificate. Full stop. The Bakijai clearance certificates submitted by the petitioner society and the respondent number are 3 society, along with their bids, are available in the case record. Full stop. On perusal, it is noticed that both the Bakijai clearance certificates were issued with validity of 365 days from the date of issuance. Most of the Bakijai clearance certificates, both the Bakijai clearance certificates were issued by the office of the district commissioner, Borpeta, who was the tender writing authority. The Bakijai clearance certificate in favor of the petition society was issued on whereas the Bakijai clearance certificate in favor of the respondent of Chief Society was issued on the Bakijai clearance certificate was issued in the name of the petitioner's society. Was issued in the name of the petitioner's society. Therefore, this finds
The fact that the Makita claim certificate dated 26/12/2022 is in conformity with the condition laid down in the Gazette notification. Yes, sir. It is in the validity of the Makita claim certificate. Correspond number 3 society was 365 days. And they were accepted by the tender settlement as a very much. And it is beyond comprehension. The court. How? The particular claims should by the District Commissioner. And L1 to be honest. If the that part of the containing the group settlement. 16,000. Correct. Nowhere in Rule 12 of the fishery rules. It is set forth that the caste certificate in the name of the authorized office here of the either registered fishery cooperative society was a requirement. As per Rule 12. Sorry,
or who can submit, no, the category of persons who can submit the bid.
weeks for settlement of a 60% share. That Special category means that includes cooperative societies, self-help groups, non-governmental organizations, private petitioner society. And the other notification. It has been prescribed that a bigger society has to submit a bigger fishery cooperation submit one certificate certifying that 100% actual fisherman certificate issued by the jurisdiction of cooperative societies, indicating that all the members of the fishermen society, SHGs, are NGOs, are actual fishermen belonging to the single class community of erstwhile Kasai district of Assam. If the secretary so what is of relevance from it is discerning behind submission of 100% self is only essential. If the authorized office bearer is a member of the bidder charity cooperative society, then he automatically comes within the scope and envelope of the 100% self-service certificate submitted by the bidder society. The backgrounds relating to the ground election relating to submission of caste certificate in the name of the affairs of this behavior of the Christian society is found unbelievable and arbitrary, and the same is found not in terms of the tender notice and the change. A issue is a charity cooperative society is registered under the provisions of Assam Cooperative Societies Act, 1949,
and stroke or the Assam Cooperative Societies Act, 2007. আগৰখন আছে নেকি? As per the provisions contained in section of the Assam Cooperative Act, 1940. Per section. One seven. Or the Assam Cooperative Society requirements. Every registered cooperative society shall be deemed to be a body corporate by the name under which it is registered, with perpetual succession and a common seal, and with power to hold property, to enter into contracts, civil and defense suits, and other legal proceedings, and to do all things necessary for the purpose for which responsible. Section 118 of the Act is prescribed for a register of members. A registered Fishery Cooperative Society, Petition Society, a registered Fishery Cooperative Society, being a body corporate, is distinct. The distinct personality separate from its members. See, normally does is a maybe what is normally the Parliament secretary?
Shareholder.
Huh?
He is a shareholder.
Okay. Because sometimes secretary is
From outside.
outside.
No, it's not. He is a secretary.
Okay, shareholder.
In the Fishery Cooperative Society, secretary must be from the shareholder.
Okay. Sri Narahari Das. The shareholder. And also acts in the capacity of secretary of the Petitioner Society. Also. But in the process of settlement of a Romari group decided, Narahari Das entered into the free speech dated 27/1/2017 in his individual capacity as an individual can also be a settlement holder in respect of the 40% of the beneficiary.
the Romari Group fishery. 40%. Comma. The tender settling authority can execute. Had executed the listings, which she normally does. For settlement of Romani, we said for a period of 7 years. And the agreed annual yearly revenue of rupees 1,41,000 per annum. So, if Norohari does in operating, the operating group, Romani group descent had defaulted in any manner in his individual capacity. Pay to deposit an amount of rupees 5 lakh, 15,275 in any manner in operating, nobody could decide in terms of the lease to 7 comma such liability which she normally does had incurred in his individual capacity and which is not in any manner related to him as a shareholder and secretary of the petitioner society, comma such purported default cannot be a ground to adjust the bid of the petitioner society submitted for settlement of Mandia location. For the reasons mentioned in none of the grounds on which the tender settling authority, that is number 1, had adjust the bids of the petitioner society is not responsible, is found unsustainable in law. Rather, the grounds of rejections are found to be illegal and arbitrary. Consequently, comma, the impugned order of settlement dated 16/12/2024 is unsustainable in law, is found and unsustainable in law. Resulting the decision to settle resulting from April. The order 1960 is set aside. Result, comma, the decision the order of settlement made in favor of the responsible three society also stands intact. With the order of settlement dated 16/12/2000. Sitting inside. Tender setting for shall proceed consider the tenders received in response to the tender of the state. Efforts in terms of the observations gainable in order to bring the process to a logical conclusion. As expeditiously as possible. But within an outer limit of 1 month from the date of prompting. So far, this is okay. Para. From the text emerged insofar as the gets a BBC number 706. How it has emerged from the discussion with the book. There was clear emission from the tender settling authority. That is the District Commissioner for it. That a substantial area of Romari group was under encroachment of a large number of illegal trespassers. As per the lease deed dated 27/1/2017, the area of the fishery, which were of area of Romari group fishery of the which was sought to be handed over to the petition was 160 acres. In the case projected by the District Commissioner Borpeta in title suits number 05/2018, the extent of encroachment was to the extent of 106 bighas. And the same 106 bighas were under enforcement of at least 60 illegal trespassers, who were made defendants by the District Commissioner of Borpeta in his additional wing. While after his transposition as painting number 2, goes to the fact of illegal enforcement to the extent of 106 bighas was revealed, was stated to be revealed from a report dated 24/4/2018, submitted by the circle officer, whatever revenue circle, who was directed by the District Commissioner of Borpeta itself to carry on a survey and demarcation of Romari Group design. The District Commissioner Borpeta, as the tender settlement has himself admitted that the petitioner was not able to operate and to carry out fishing even after the execution of the lease on 27/7. And had himself and has sought the relief before the trial court. That's for the relief. The District Commissioner Borpeta, by virtue of the power authority jurisdiction vested by the Assam Land Regulation 1886. By the Assam in the Hamada District Commission Borpeta himself to give the alliance of Romani Group deciding which is governed by government lands, by eviction of all the illegal trespassers. Instead of exercising such statutory power, when instead of exercising such power to evict the illegal trespassers, the District Commissioner to see the in the form. The district commission ordered himself with paid to hand over the position of primary study in an enforcement-free manner by taking actions to evict the illegal process, the demand made by him for the amount of rupees 5,000 by the impugned demand notices dated 10/1/2025 and 27/1/2025 are clearly unjust and arbitrary. Full stop. Such action to perfection behind demanding the same amount as outstanding areas are not an action which can be turned bona fide. And such way of the media, such government dated so are set aside in past. The observations made, direction given you. The two regulations stands allowed to the extent indicated. There shall, however, be no order. Anything missed? It is really no, while deciding the matter of settlement. Oh, only to share. The tender setting authority shall consider the same strictly in terms of the gazette notification super. That law, because that has been made now by the Supreme Court. By the Supreme Court now. That you consider all settlements in
And
terms of that notification. Have you,
Yes, yes, I've gone through it.
so,
That doesn't.
but I have said a long time back. Maybe. What about other?
In just Simba itself.
No, I have many things. I'll keep it someday else.
So,
Because I need to do correction also.
mile.
6 to লিখি দিয়ক। 6, no?
6.
That's going to be Sharma. Yes, I will. This one, so this one, this one. What about 7? Yes, sir. Yes, madam, what is your instruction?
Apparently, there is last 3 days.
Last?
Yes.
No, have you should have checked for the entire amount. No, my lord. Oh, my lord. Now 15 lakh remains. About 16. If your serial number is 103,
One.
then when it terms comes, why will keep it pending? Why will keep it pending? We'll give him an extended time period of 6 months. If it is not there, because your serial number is 103.
My lord.
Because because the order says strictly in terms of Tamsir Ali.
I'm sure. My lord.
Now they have gone to release 15,000 something,
My lord. 15 lakhs.
whatever. Now 16 lakh remains. Your position is 103. That has been certified by secretary at least.
My lord.
So we close it, allowing them 6 months time to pay the amount. If not paid, you'll have the option of or liberty of approaching this court again.
My lord.
We'll
Then
not
in that
keep
case-
spending 103. We'll wait.
Yes.
It is no point.
Why?
No point waiting.
If that
You have the
is- then,
liberty.
my lord, we have no objection.
I'll clearly observe that you'll have the liberty. If this amount is not paid, then liberty stands reserved to the petitioner to approach this court again.
My lord.
That's all.
As per this.
Let him come, then you say that now his position is 50. Okay. Alright, Mr. Vidas petition. And this N. Chaudhary, Learned Council Order. As per number. Right. Yes, at the time they have submitted para 6 months. But see my order. I am careful in passing the order always. So I said, if after such exercise, a petition is found entitled to that amount of so or any other, the same shall be released in favor of the petition in terms of the changing Tamsir Ali. So Tamsir Ali is sufficient.
The council, that and council of the BTC. my
But
lord,
this
that-
is what is important is my
Yes, my
order.
lord. But at that point, they have
I
considered some
recorded
other
the
things.
submission.
Yes, yes.
But the decision is in
My lord, that I understood.
in para 7.
Yes.
In terms of Tamsir Ali.
Tamsir.
And Tamsir Ali says, maintain a list, continue paying. Para this contempt petition. Yes. Paper. Telling. On compliance. Of the directions. In a moment. Past. In the big petition, the petitioner saying that he executed a contract work against him. Here it is. After the petitioner had claimed that after executing the contract work, the contract value of rupees 3,007. The petitioner submitted his final bids for an amount of rupees 98 lakh 64,706. Prior to filing of the litigation, the respondent offered to the government disbursed an amount of rupees 68 lakh 44,701. The requisition was prepared alleging non-disbursal of the remaining amount of rupees 30,19,955. And the direction was sought for. Direction to the responding authorities, the PDC, to release the remaining amount of rupees 30,19,955 was sought. The court, taking note of the submissions made by the United Council for the parties and an order hearing number dated 15/11/2000 from disposed of the requisition or by the order dated 20/06/2020. The operating parts of the order is there under this. When a period of more than 11 months. No, the contempt petition was filed on 20/06/2000, stating that aside despite the direction made, the order dated 15/06/2000, the remaining amount of rupees 30,000,000 had not been released. Where the respondents were put to notice on how many petitions are filed?
One affidavit in opposition, one additional affidavit in opposition.
One. And then this revenue. Were filed during the course of the proceedings. Whereas in the additional affidavit filed by the respondent, comma. It is stated that subsequently sanction was recorded for payment of an amount of rupees the said amount was reduced by the check. Mailing number 062. As a result, comma, an amount of rupees 16 lakh 25,000 as the remaining outstanding building, correct? Where in addition, it is also mentioned in the addition of rules that the BTC authorities have already placed demand before the state government for providing a balance fund for payment of liabilities. In turn, with the Assam State Finance Commission, SMC. On 10/12/2021. The BTC authorities have also prepared a list of liabilities wherein the contract of in respect of which the petitioner has made the demand is listed at serial number 1. The said list is totally as the current principle of some said list strictly in terms of two instances. आपसे रही versus and others versus stable or sound and others 2008 to 21, which direct the state respondents to keep and update, keep a list of liabilities in chronological order and to pay the outstanding amount. On the basis of the same list, by keeping the list duly updated from time to time. As in the list of liabilities, the petition is being figured the contract and the reference. Figures that serial number 102. About the remaining amount of which 16,45,000 can be released to the petition by following the mandate in Council Super and the same would require a reasonable period of time. 6 months. But having regard to the other, after filing of the contribution, the and a part payment to the extent of rupees 1 lakh 9,977 has been made on 22/01/2026. In the list of liabilities, the contract of the difference figures at 106. Still number 106. And the outstanding amount is rupees 16,45,272. 103. Okay. Full stop. Therefore, if this taking note of the direction of the commander submission made by Mr. is found deserves acceptance. First of all, therefore, this contempt petition is closed at this stage, allowing the respondents to 6 months time to disburse the remaining amount of rupees 16 to the petition. First of all, in the event, it is further observed that in the event the remaining amount of rupees 16 is not released to the petition within the next 6 months time up to date, the liberty stands reserved to the petitioner to approach this court again, invoking the content. Relief for 6 months. Extend jail